Hello everyone and welcome. My name is Damian Clifford. First of all, I'd like to acknowledge and celebrate the first Australians on whose traditional lands we meet and pay our respects to the elders past, present and emerging. So I'd like to welcome you to this ANU Ninian Stevens Cyber Law Programme event. So this is a programme that's actually funded by the Menzies Foundation, and it gives me great pleasure to introduce what is an all-star panel. First of all, I'm going to keep the introductions very short because we have a limited amount of time and we have an awful lot to discuss. So I'm sure with the power of Google, you can find out more about our speakers. But first of all, it'll be Professor Lee Bygrave from the University of Oslo. Then we have Professor Megan Richardson from the University of Melbourne, Dominique Dalla-Pozza, Dr. Dominique Dalla-Pozza, from my own institutions here at the ANU College of Law. And we have Associate Professor Stacey Steele, who's based at the University of Melbourne as well, but she's also an Associate General Counsel at S&P Global. So she's going to be wearing two hats for this discussion, which is very relevant, and I'm delighted that she will, because it kind of will hopefully ground what we're going to say in reality somewhat. So the purpose of today is to discuss the ruling by the Court of Justice of the European Union on effectively the legitimacy mechanism that essentially underpinned or transfers of data from the EU to the US. So the so-called privacy shield, and also the standard contractual clauses, which are used as an alternative mechanism. Now, essentially, I think a lot of you will already know somewhat about the decision, but just very briefly, the decision effectively nullified or found invalidated the privacy shield arrangement and drew into question the validity of continued use of standard contractual clauses, albeit still recognizing that they can be used, but rendering them a little bit open for criticism in terms of their efficacy. So I think after that brief setup, it might be good to get a kind of a general overview of the context of the judgment, and just to get a better understanding as to where this ruling lies in terms of the historical development around data protection and privacy regulation in Europe. And I'm going to turn to Lee first. So I'm wondering your own thoughts about, you know, how the Schrems II decision fits within the broader historical context of data protection and privacy development in the EU. And I suppose more generally, why these issues are taken so seriously in the EU legal order.
Okay, thanks very much, Damian. Nice to be here, there, everywhere, as it were. On this webinar. As I think many of you will appreciate, there's a very long history of regulating transport of data flow within European data protection regimes. This regulation goes all the way back to 1973 with the world's very first national data protection law. That was the Swedish Data Act. And the Swedes introduced rules that restricted the flow of not so much personal data back then, but personal data files from Sweden to pretty much all other countries apart from Sweden. And contrary to claims by predominantly US business organizations back then, these restrictions were not instituted in order to promote economic protectionism. They were instituted primarily out of a fear of so-called data havens, somewhat similar to tax havens. So a fear that unless there were restrictions on the flow of data or data files from one country to another, then there was the distinct possibility that those data would go to other countries which had more lax protections for them. And so the rules were there to stop, in effect, that circumvention of local and relatively stringent data protection. And this system was then taken on board by other European countries, and eventually the EU embellished and strengthened the system considerably. Note too that in very recent years, when the EU has been promoting its system for transport data flow regulation, you can also discern often between the lines that the EU, particularly the European Commission, is using the leverage it gets from its relatively stringent restrictions on flow of data from the EU to other countries, so-called third countries, as a quasi-proselytizing tool for promoting its vision of what is good data protection, what is good data governance, what is good law to the rest of the world. And I think we've got to bear that in mind as well, although I don't think it's a major part of the equation here, but it is nonetheless something that is there and wasn't there at the very start when Sweden and other individual European countries started off on their TBDF regulation quest. Now, as the EU has embellished and strengthened this system, there have been many scholars and policy entrepreneurs, myself included, that have criticised the system for being seriously dysfunctional. If you look at the number of formal adequacy assessments undertaken by the Commission, there are just a handful of countries that have received a formal adequacy finding. And let's face it, most of these countries are hardly big players geopolitically. Many of them are minnows, Andorra, Isle of Man, and the like, right? At the same time, the whole process to get an adequacy finding, as we'll probably come back to in this webinar, is extremely intricate, extremely cumbersome, extremely drawn out. And the Australian case is a good example of that. And so it's not surprising that we've only had a very few number of formalised adequacy decisions. So that's meant that the alternatives, such as standard contractual clauses, which figure in the Schrems II judgment, have become relied upon by many companies and organisations that are transporting or transferring data from EU jurisdictions to so-called third countries. In some ways, this whole regime has become a situation where the EU is caught between a rock and a hard place, in the sense that if properly implemented, the regime is likely to collapse from the weight of its very cumbersome and bureaucratic procedures. On the other hand, it could well collapse in reality, if not in name, because of large-scale avoidance of its proper implementation, precisely due to the fear of all of those cumbersome bureaucratic procedures. And many say that in today's internet age, where you've got terabytes and terabytes of personal data crossing geopolitical boundaries nanosecond after nanosecond, that these sorts of frameworks are just hopelessly out of date. They are tilting at windmills, in effect. But Schrems II and Schrems I, as I'll come back to, they challenge this narrative somewhat by showing that transport data flow regulation, at least from the EU side, must be taken seriously. And the Court of Justice of the European Union has increasingly taken a very stringent view of what is required in this respect. So from the Court of Justice's point of view, we're not just talking about symbolic ritualistic exercises, tick-boxing exercises that will allow the seamless flow of data from EU to other countries. There has to be a proper, stringent assessment going on that involves not just assessment of law in the books, but also law in practice. Is there really a data protection culture that has traction in the recipient country? And the US has been found wanting now twice. if you compare Schrems II with Schrems I, the interesting thing is that, in a sense, Schrems II ups the ante. Schrems I, the Court of Justice was able to shoot down the Safe Harbour Agreement partly on rather formalistic reasons. The European Commission had not reached a formal adequacy finding when it came to the USA. So it entered into its Safe Harbour Agreement with the USA prior to such finding, and that, said the Court of Justice, was a procedural error. And secondly, when the European Commission did enter into the Safe Harbour Agreement, it cut out the ability of data protection authorities in European countries to sort of circumvent that decision. And as the Court of Justice said, even if the Commission makes an adequacy finding, and while that adequacy finding will be binding on data protection authorities in Europe, you can't, as the Commission, stop people, including data protection authorities, from questioning the validity of that adequacy finding and going all the way to the Court of Justice to do so. So there were a couple of formalistic problems with the old Safe Harbour Agreement that weren't found with the Privacy Shield Agreement. In Schrems II, the Court of Justice goes, in a sense, straight for the jugular and basically says, sorry, once again, the US legal system, when it comes to the activities of law enforcement agencies there and their ability to access and utilise personal data flowing through subsea cables, etc., all that is not subject to sufficiently stringent controls in conformity with the proportionality principle. So the Schrems II judgment has, in a sense, increased the seriousness of the adequacy assessment. At the same time, as you can see, it's a natural progression from earlier developments.
Well, thanks very much for that. I think a very comprehensive answer and really insightful. I suppose, a conclusion from that really is that, there have been certain developments in the US around, I'm thinking, I suppose, the California Consumer Privacy Act, and there have been rumors and attempts, I suppose, at the federal level to introduce some sort of a federal data privacy law. But on the basis of your conclusion there, effectively, this means that, that's only part of the picture. I
agree, Damian, fully, yeah.
Okay, but I suppose there's another question then, I suppose, building on from that. I suppose, this has really concerned, to a large extent, you've been speaking about EU to US transfers, so I'm wondering a little bit if you could reflect on why that is important for Australia. I think you're somewhat uniquely positioned to answer this as, an EU data protection expert who is also Australian. So I was wondering, I suppose, what do you think yourself, I suppose? Should we be concerned about this judgment at all on this side of the world? And if so, why?
Well, I think this webinar is very, very justified. And yes, there should be concerns in Australia. While Schrems II does, as you say, affect directly transfers between EU and the USA, there are obviously lines of principle being drawn by the court that are applicable to all third countries, Australia included. And again, in a historical perspective, the issue of Australia's adequacy in European eyes, this isn't new. If you think right back to the reforms of the Privacy Act that kicked in 2000, where the Privacy Act was extended from being an act applying to federal government agencies to large tracts of the private sector, those reforms were to a large extent catalysed by the passing of the Data Protection Directive, which in Articles 25 and 26 of that directive instituted the same sorts of restrictions as we now find in Chapter 5 of the General Data Protection Regulation. And obviously the Australian government back then was concerned and tried to go a considerable way to meeting the demands, standards of the European Union. And there were indeed several assessments made of the adequacy of the Australian data protection regime. And these were assessments not just of what is out there at Commonwealth level, but also at state level. They were very comprehensive assessments. I, together with Graham Greenleaf from the University of New South Wales, we contributed to 2 of those assessments. Significantly, the last update we did was back in 2007. And Damian, you will, being a European, that's significant because, as you remember, that's when the Lisbon Treaty basically kicked in. Well, short time later, December 2009, and it's at that time that European data protection law starts to get this very, very fundamental rights character. It's at that time the Court of Justice starts to take off its gloves, as it were, and say, right, we are fighting for these rights. They are fundamental. We're going to treat them as fundamental rights. We're now going to start really applying the proportionality principle stringently, and all aspects of the proportionality principle. And I don't know what's been happening in the back doors in terms of communication between the EU and Australia, or Australian government, in the time since. My sense is that there's a bit of a standoff. There have been no serious moves by Australian governments to cut back on the small business operator exemption, the exemption for employee records and the like, that have been stumbling blocks for these EU adequacy negotiations. And if anything, this is a view from afar, and please correct me, my sense is that the state of data protection in Australia is not improving, it's getting worse, not least with respect to the effectiveness with which data protection agencies are able to deliver on behalf of data protection, and the ability to deliver has become more important in the last decade from an EU point of view. So I see this, I'm not sure if Schrems II is going to be a catalyst that will reignite negotiations between the EU and Australia when it comes to reaching adequacy finding. There are other people participating in this webinar who probably have a better sense of what is going to happen there. But it's not going to go away.
Yeah, well, thanks very much. I think that's probably a good moment to bring Megan in then, because, I mean, the ACCC and their Digital Platforms report in their broader reforms of the Privacy Act has actually suggested going for an adequacy agreement. So it's probably a good time now to turn to Megan and ask a couple of questions and see what she thinks. But I suppose Lee has already alluded to some of the obstacles that have prevented an adequacy agreement historically. But I was hoping that you could, provide a bit more meat on the bones there and tell us a few of the reasons why there hasn't been an adequacy agreement in the past.
Okay, so thanks, and that's a great start. And thanks very much, Lee, as well, for filling in that background. I think that if we want to go more into detail, we could start by looking at the EU Article 29 Data Protection Working Party decision in 2001 on the level of protection that came out of the Australian Privacy Amendment Private Sector Act. So that's the act that extended, as Lee said, to the private sector. And there the Working Party was quite explicit about the obstacles that it saw to adequacy. And most of these still remain. And I think he's right to say also there are others that are going to become more problematic, not just on the Australian side, but also on the European side, because the standards have been expanding and growing there as well. But just to look at the historical ones, I think Lee mentioned already the small business and the employee records exemptions. And these are highlighted in the opinion of the Working Party in 2001. So it specifically identifies a small business exception and says that the problem here is that only small businesses that are deemed to pose a high risk of privacy are required to comply with the legislation. And if you look at our Privacy Act, we still have a very broad definition of small businesses, basically the same one. Section 6D says that small businesses are businesses that have an annual turnover of 3 million or less. So that's apparently over 90% of Australian businesses, well over 90% of Australian businesses, according to the ACCC. And there are some exceptions to this definition of small business. So businesses that provide a health service or hold health information, that's one exception to the small business exemption. There's another exception or carve out for businesses that collect from third parties and or disclose personal information about another individual to third parties for a benefit, service or advantage. So it's trade and data kind of carve out. There's a further qualification on that, unless the collection or disclosure is carried out with the individual's consent or required or authorized by legislation. And then there's a third carve out that small businesses contracted to provide a service to the Commonwealth, so brought back in. So there are some exceptions to that small business exemption, and you might think that those exceptions are becoming more important, particularly the health one. Health information is so pervasive now, and also the trade and data one as well. I know the Privacy Commissioner has taken the view that that potentially could be very expansive now, but it's still the case that we have this very broad and uncertain small business exemption in our Act. And that was a concern of the Working Party in 2001, and I think it would continue to be a concern now. It's also an exemption that our government has been very strongly wedded to, and throughout a lot of our laws, including the Australian Consumer Law, for instance, we see special kinds of treatments of small businesses, which are often treated as more aligned to consumers than to large businesses. So it may be difficult to see that exemption going easily. For instance, the Australian Law Reform Commission, in its 2008 report on the Act, For Your Information, Australian Privacy Law and Practice, that saw some changes to the Act, including our current APPs, or Australian Privacy Principles, recommended that that exemption be revisited, but the government did not accept that recommendation. Then the second exemption, employee records, was also noted by the Working Party in 2001, and this exemption covers data in employee records held by an organisation and relating to an individual. And that's, again, a very broad exemption. It covers all kinds of information about employees and records, including about their employment, the terms and conditions of the contract, evaluated material about the performance of the contract, emergency contacts, trade union membership, recreation, long service leave or long leave, or recreation long leave, sorry, taxation, banking affairs, etc. And the Working Party thought that employee data, including especially sensitive data, should be protected, for instance, from the disclosures to third parties, including future employers. And again, this seems to be an exemption the government is wedded to, although the Fair Work Commission's 2019 decision in Lee and Superior Wood, this was a case in which the Fair Work Commission held that biometric data collected before being placed in a record is still subject to the Act's protections for sensitive data because it's not yet in an employee record. I think that has quite significantly limited that exemptions or assumed operation, put it that way, and meant that the Privacy Act might now apply. And we have a recent case I just saw of Kieran Knight and One Key Resources Mining Limited, which again was treating information before being placed in an employee record as subject to the Australian Act requirements, the Privacy Act's requirements. But having said that, again, we have a fairly substantial exemption there, and one which may well prove to be very problematic if it remains. There are other exemptions or limits under our current Act, which I think might be considered to be problematic as well. Journalism, we have a very broad exemption under Section 7B4 for journalism. It's not premised on public interest or proportionality as it is in the European, usually under European standards, for instance, in the UK. And we also have a rather unusual exemption for political acts or practices under Section 6C and 7C of our Act, a very broad exemption which apparently was brought in on the basis of the implied freedom of political communication, but without any qualifications about proportionality, for instance. And I see there's a very nice chapter written by Maury Patterson and Norman Whitslip on voter privacy in a recent book, which has really questioned the need for that exemption, including the need for it, given that the implied freedom of political communication has its own limitations. And so I think those exemptions again raise questions regarding adequacy, ongoing questions regarding adequacy. And if you consider the provisions about adequacy in the GDPR, which Lee has reverted to, they do make clear, I think, that both the public and private sector will continue to be under the microscope in assessments of adequacy under the GDPR, and including that these kind of total exemptions that might be made, or very limited scope of application in other laws. I think also this seems to be consistent with the spirit of Schrems, that we would expect to see these kinds of special privileges for certain kinds of activities as quite dubiously regarded.
Thanks very
and
much.
Personally, if it comes to what are the, this point that Lee was making about a kind of best practice being offered by the European Union, I myself think it would be better if we followed the European standards in this regard. And it's not just a matter of adequacy, it's a matter of good law. In fact, the ACCC in its 2019 digital platforms report that Damian was talking about, it raises the question of these exemptions in its suggestions for further reforms, even apart from the question of adequacy. So it says, maybe we should be thinking about these exemptions, for instance, for small business employers, registered political parties. And the government has flagged a review of the Act in response to the ACCC's digital platforms report, but without suggesting the exemptions would be the focus of this review. So I think it's still very difficult to know what's going to happen with those exemptions on the Australian side. And given the Working Party has singled out at least some of them in the opinion, and given that the ACCC itself has wondered about the merits of these exceptions, I think there are good reasons to think we're going to have problems in Australia for data protection. Sorry, Damian, you were going to say something.
Oh, no problem. You were on a roll there, I suppose. So I was happy for you to continue. I suppose just, I mean, based on what you're saying, then, I suppose just to summarize it a little bit. So, I mean, even if the ACCC recommendations were adopted wholesale, I mean, the ones that they're, aside from the broader reform of the Privacy Act, I mean, the ones that are contained in recommendation 17, would I be correct in assuming that you would see that there would still be many barriers to adequacy? I mean, that there could effectively, even with the adoption of those recommendations, that there may be still barriers in light of the Schrems decision and the GDPR.
Okay, so now we're thinking that the ACCC's recommendations, which include other things as well, which could be issues for inadequacy finding, for instance, about the broader definition of personal data, also beefed up standards about consent. I think those are two other features that you see in the ACCC's recommendations that would certainly make adequacy easier if they were followed through on. There's the question of, well, what else might be needed as well? Well, Lee's raised the point about enforcement and enforceability. I think the point about the laws of these third countries, including Australia, are they really doing enough to protect data protection right through the whole process, not just in terms of law on the books, but also in terms of how the law is applied and available? And I think that's a very legitimate question to ask about the Australian regime. And for instance, we have very few determinations from the Privacy Commissioner under our Act, and individuals cannot bring claims for damages on their own account directly to court, individually or collectively, although they can seek an injunction under the Act. So that's very different to the position under the GDPR, where individuals or groups can bring actions, and that has been a major source of elucidation of the legal standards, as for example in Schrems itself, and Schrems I and Schrems II. So in a number of other cases where the European Court has got involved have been brought by individuals or by groups like the Digital Rights Ireland, for instance, the civil society group. And the ACCC, I mean, has recommended that should change, and the government in its response has indicated that it's open to the idea that individuals should be able to bring claims. And so I'm hoping that that will change with the Privacy Act, and also that the government's indication of expanded powers for the Privacy Commissioner and resources might also be a good move. But even that said, I still think that there are some things that maybe will turn out to be important, not necessarily initially, but down the line in terms of comparing our standards to the European standards. And it's not necessarily just a question of adequacy, it might just be a question of the appropriateness or the desirability of our legal standards. I'm thinking here, for instance, of the new kinds of rights that are elucidated in the GDPR, that are spelled out more in the GDPR, and I think are going to start to set standards for a lot of the other parts of the world as well. For instance, regarding data portability, automated decision-making, the right to be forgotten or right to erasure, these things might affect adequacy assessments, but also they just are raising the bar in terms of what you should expect from a good data protection regime in the modern times. And it's not necessarily the case that we all need to have the same laws here. And even when it comes to adequacy, we see from the just general standards to be applied, we see in the CNIL case last year in the European Court of Justice, the idea of a worldwide right to be forgotten was rejected by the Court of Justice of the European Union. So even there it's accepted that we don't all have to have the same laws, but we still might expect to have something in terms of trying to reach these standards or some kind of general consensus that these are good things and what we would expect in a data-driven society. We do seem to be getting data portability with the consumer data right, but still very much on a sectoral basis. The ACCC has indicated its intention to explore this further in terms of its benefits. Further, we do have some provisions regarding access and correction in our Privacy Act and the APPs, especially around APPs 10 to 13, and quality of information generally. Plus, the ACCC has recommended a right to erasure, which I think is very interesting in its report. The government has said it will consider that in the proposed review of the Privacy Act in response to the ACCC's recommendation. So that's a good thing, but let's wait to see what happens there. And so far, I think there's been very little movement on the issue of automated decision-making, and I think we can expect to see a lot more debated here. So there's still a long way to go, I suppose I would say, in terms of what kinds of standards we should be meeting, maybe formally in terms of adequacy, but I think even more importantly, perhaps, in terms of the quality of our laws themselves.
Okay, well, thanks very much. It's very insightful again. I think, I think this kind of points back to something Lee alluded to when he was speaking about the Lisbon Treaty, and the significance of its entry into force in 2009, because it effectively brought with it the Charter of Fundamental Rights of the European Union. I'm kind of wondering as well, to a certain extent, to what extent, a jurisdiction like Australia, without, this Bill of Rights, without a comparable right to privacy or right to data protection as we have in the EU Charter, effectively limits the capacity here. So, I think it points to a certain degree to what you were alluding to as well, in that, allowing for a certain degree of difference, but at the same time recognizing that these are extremely important values. But kind of fundamentally, there appears to be a difference. So I'm wondering if you have thoughts on that.
Yes, I think that's a really, really good question, actually. I think ultimately a constitutional right to privacy is something that's going to become seen as increasingly important. And whether we will end up with that is a big question. I mean, for a long time, I think we've made do with what we've got. So we have something which we might call a common law right to privacy, and we see this coming through, not necessarily in so many words, in our breach of confidence privacy cases, where the courts have really managed to turn this rather traditional doctrine into a de facto privacy tort. For instance, in last year's class action Evans and Health Administration Corporation regarding the sale of ambulance drivers' health and other personal data to a law firm, that was dealt with inter alia on the basis of breach of confidence as a kind of de facto privacy tort. And so we can see kind of movements within the common law for what you could call common law right to privacy, even if we might think it would be good to have this more spelt out and even an actual tort, as the Australian Law Reform Commission and ACCC both recommended, and the government has said it will consider that again in its forthcoming review, we'll see. I think even more interesting recently has been what's been happening on the constitutional side, though. And for those who get a chance to read that chapter by Norman and Moira on the political exception, they'll see they have a very nice discussion of the constitutional cases and the way that privacy is dealt with in the kind of around the edges of the implied freedom of political communication. And maybe one day we will get something which looks a bit more like an implied freedom on the side of privacy, or tied to political communication as well, or else even more independently of that. We have a case this year, the Smethurst, the Commission of Police decision, which was about the police search of journalist Annika Smethurst's home. And in this case, which ended up in the High Court, there was an argument about the implied freedom. It was a case that looks a bit like a Fourth Amendment case in the US, or a case about the right to privacy or private life or the right to data protection in Europe. But in Australia, it was dealt with under the provisions of our Clients Act about reasonable search and seizure. And so we see the courts are finding ways to grapple with these questions that might be considered almost constitutional questions or quasi-constitutional questions using the tools that they have available. But we might see ultimately something further. We might ultimately see some more ambitious setting out of something like an implied constitutional right to privacy or something added to our implied freedom of political communication that really gives teeth to this idea that privacy is increasingly to be understood as a political issue and not just an issue about commerce or trade or individuals.
I think that's probably fine to kind of bring it over to Dom then, because I mean, it's kind of bringing in some of the public law aspects. And I mean, we heard from Lee earlier that I suppose the Courts of Justice, by kind of going for the jugular, they were kind of really going after law enforcement access effectively in the US. So, I mean, as a non-public or Australian public lawyer, I was kind of wondering, well, what are the relevant frameworks in this jurisdiction for law enforcement access to data held by companies? I mean, effectively, this kind of explains my motivation for having this webinar. And like, to whom do they apply? And are there controls in it? Are there kind of proportionality, necessity type ways of thinking that I would be familiar with as a tradition? I mean, I have an EU law background. So Dom, I'm hoping that you can fill in the gaps here for me a little bit.
There's a lot of gaps to fill in there, Damian, and I just want to thank you for the opportunity to speak on this panel. I am the odd duck here as a domestic lawyer who is a public law and constitutional scholar with a particular interest in national security law. So I'm learning a lot from listening to the eminent speakers on your panel. When I had a look at that question, I did try and make a list of the relevant legal frameworks that provide or at least facilitate access to data for law enforcement and for national security purposes. And I eventually gave up because there's so many different frameworks and that they interact in really unusual sort of ways that I was turning into a bit of a list-making exercise. And that's part of the problem, I think, when we're looking at data protection, that when you're talking about it from a public law and from a law enforcement standpoint, you're thinking about getting the data from people, not protecting the privacy associated with it. So look, the top three that come to my mind in terms of legal frameworks, at least at Commonwealth level, and there are, as Lee averted to, an issue with the Australian framework is the fact that we've got a federal system. So we have laws for law enforcement that operate at the state level, at the regional sub-level, as well as the Commonwealth law that comes over the top. But sort of the two of the most prominent Commonwealth pieces of legislation are the Telephone Interception and Access Act. It was passed in 1979 and gets amended, with quite frequently. And most recently, the amendments that this audience is probably at least a little bit familiar with were the amendments in 2015 to do with data retention. So that was the last time the TIA, as it's known to public lawyers, got a significant amount of public attention. But even overtaking that, we now have the TOLA, the Assistance and Access Act, which does something a little bit different and actually provides for certain types of notices to be issued, which require designated communications providers to provide technical assistance to facilitate access to data. And those two laws are really quite significant challenges, I think, to the way in which data is protected in an Australian context. And the final one I'll just throw in there is to remember that when we're not talking necessarily about law enforcement, but we're talking about intelligence and national security, you also have to remember the powers that are given under the Intelligence Services Act to intelligence agencies such as the Australian Signals Directorate and the Australian ASIS, the Australian Secret Intelligence Service, to collect data in the context of collecting foreign intelligence or intelligence on people outside Australia. And then, of course, there are the broad powers that ASIO has in its own act to collect information and intelligence relevant to security domestically. So you've got at least 4 different acts here that interact in really unusual and interesting ways. But I suspect, you know, that I'm going to talk a little bit more about the Assistance and Access Act just because it's on everybody's mind at the moment. And I would particularly recommend to the audience here, if you haven't had a look at it already, the recent report of the Independent National Security Legislation Monitor into the Assistance and Access Act. It became public in July of this year. And that particular review process came up with some really interesting recommendations for reform of that particular act. And there was a nice discussion about the state of privacy law in in Australia as it applies in a national security and sort of public law context. And it's quite short, which I appreciate. So if you're interested in these issues with a public law bent, I would probably have a look at that. But in terms, so one of the things that the Assistance and Access Act does is allow so just using national security as an example, it allows the Director General of ASIO to basically issue a notice called a technical assistance notice, which can be directed to a designated communications provider, and which says basically, we need to be able to access this data and you have the capability to allow us to access this data, and we're going to compel you to provide us with that technical assistance. And there are terms that as a European Union law specialist you would recognise. So they do talk about proportionality, they do talk about privacy, and the fact that it has to be what's required under the assistance notice has to be reasonable. But I'm not sure that those concepts in this particular context would play out in the same way that they would in a European scenario. And one of the main reasons for that is, as you've said, the lack of a constitutional set of protections for these sorts of rights at all. So when we're talking about what's reasonable and proportionate, it means a different thing to Australians and in a public law context than it would mean for you. And so that's what's really interesting about, for me, the Schrems II decision, having been quite late to realise its impact myself. To what extent are we going? Is Australian national security law or law in relation to law enforcement going to feel compelled to respond to what was decided in Schrems II?
Oh, that's great, thanks. I suppose it kind of raises another question in my mind, because I mean, the Court of Justice in its ruling in Schrems II was obviously fixated on the Foreign Intelligence Surveillance Act. And now I realise that this is a bit of an impossible task, but I mean, if you were to kind of broadly compare them, if you could, or I mean, feel free to dodge this one, because I realise that it's a difficult question. I mean, if they were particularly worried about that act, should they be worried about the regimes that currently exist in Australia, given the hodgepodge and the broad powers that I think exist?
Well, I'm obviously not qualified to speak on behalf of the European Court of Justice, and you're right, it is inherently difficult to compare US national security law and the public law structures around that with what occurs in Australia, and there's 2 reasons for that. One is obviously, again, the constitutional contexts are very different. We don't have a due process right that's constitutionally protected. In our constitution is one really big example that's really important in this field. But the second is that our national security apparatus doesn't look at all like the US multiplicity of agencies that do the work of intelligence gathering. So it's difficult to map on to FISA exactly what happens in Australia. That said, one of the really interesting points that was made by the INSLM, the Independent National Security Legislation Monitor, speaking specifically about the Assistance and Access Act, is that, and one of his key recommendations was that we should change the way in which these intrusive administrative notices work by making sure that the decision to grant such orders was given to the Administrative Appeals Tribunal, and he even recommends adopting something similar to the investigatory powers model that's in the UK. And the point that Insular makes there is that we need to do more to make it very clear that the decision to grant these powers to law enforcement or national security bodies is incredibly independent, like even more independent than the current legislative framework. And my feeling is that the Administrative Appeals Tribunal might be closer to what seems to be envisaged in the Schrems II decision than what we've currently got. So again, it will rest on the extent to which the Insulam's recommendations in relation to the Assistance and Access Act are taken up. It would be a significant departure to take this power out of being approved by the executive, and indeed in the case of ASIO, sometimes in some cases even being approved by the head of the Domestic Security Agency, and taking it to a quasi-judicial, even if they are using a weird exception to our constitutional principles to get there. That would be a big movement away from the model that law enforcement and national security is traditionally used to in this space, but it might be something that we need to consider, and we might deploy and refer to the Schrems II decision as additional justification for making the changes that the Insulam suggests.
Oh, okay. Well, thanks very much for that. I think it's kind of a good moment to bring Stacey in then, because I mean, we've kind of heard, I suppose, the private law implications and law reform. I mean, of course, Lee set the stage, and then with Megan, with, I suppose, any potential reform and what might bar it, and then Dom with the public law insights. But I'm kind of curious as well as to how businesses are currently coping. But I thought maybe to kind of set the scene a little bit, you know, personal data processing seems to affect every type of business, no matter what kind of business you are. So I'm wondering if you could just kind of break down for us how these types of issues are kind of dealt with within a business. And, you know, are there issues in terms of allocating responsibility? Now, obviously, you don't have to take examples from your current workplace, but I suppose just generally, because it kind of gives us a better indication of how issues like this are actually currently being dealt with. You're muted.
Thank you for giving me the out that I don't need to give specific examples from my current employer, and my comments are not a reflection on what my current employer or the university my other employer might think about these issues. But at the end of the day, it does depend to a large extent what sort of business you are and then how you are set up internally. So it is not a one-size-fits-all answer. And from my perspective, I work for a company with over 20,000 employees operating in over 30 countries. We are B2B, which is a little bit different to your Facebook, which is the focus of the Schrems II decision. So I think companies like ours are to some extent waiting to see what happens for a couple of reasons. I'll expand on those in a moment. Not because they don't want to comply, but because we're trying to figure out how to comply. And to some extent, we've been promised by the European Data Protection Board more guidance. We are seeing individual data protection authorities in Europe come out with their own view on Schrems II. It's hard to keep all of your children happy, I have to say. And then at the end of the day, you have people in different departments that you really need to come together. So it has to be a team effort. And from my experience, most of the responses that I've seen in industry are being led by the legal department or the privacy portion of the legal department. They're the ones getting the word out about the decision. But then you need to bring to the table your procurement team, because they're the ones dealing with vendors, asking you the questions about where you're sending their data. Then you have to deal with your clients, because you do get some information from clients, in which case you're the vendor, right? You're the supplier to them. Then you've got your IT department who wants to know if they can close down a server in Estonia and move it to somewhere in Mauritius or wherever it might be? Is that going to be okay? Have we caused an international data transfer incident? You then probably have the people team. That is a big part of my world because we are B2B. How we deal with our people data, can we transfer it? You know, under GDPR, consent is not something that they think can be freely obtained from an employee. So that consent option is very difficult to implement for employee data. So that's just, and then there's InfoSec as well, your information security team. So what I would say, Damian, is I don't think anyone's trying to shirk responsibility, but we haven't quite figured out yet where these responsibilities lie within the organisation. So it has to be a team effort. And I do think that the successful companies here are going to be the ones that partner best with their IT function, whatever that might look like. You know, it might be the digital workplace people, or it might be the help desk, or it might be the people doing your cloud architecture, or it might be the InfoSec side of the house, which some people might have in IT. So you're going to have to partner with those people who are actually controlling where the data goes and can genuinely confirm to you those data flows. And finding an IT person who can also speak enough non-IT speak, and finding a lawyer who can speak enough IT speak and can come together and work on such a project is very complicated. So really, unfortunately, it depends on the organisation, but it's going to have to be a team effort.
Okay, wow. I mean, I suppose then I'd like to move on to some of the, you know, the compliance issues that and the compliance burden around this, because I mean, we heard from Megan about, you know, the ACCC recommendations and what they might mean, and like it could result in a bit of a hodgepodge from my reading. And I'm kind of wondering, you know, if those recommendations were adopted, would effectively that make your job a little bit harder in a sense, because, you know, you result in varying standards. And I'm wondering to a certain extent, okay, well, Schrems could be a catalyst for reform, but the shape of that reform could be very important for business. So I'm wondering, I suppose, your reaction to that.
I think the key pointer for me here in Australia is really the government's response, where they have spoken about interoperability. They don't want to go, I think, and be an outlier. So they don't necessarily want to go and introduce things that aren't being seen in other jurisdictions. But as we all know, the ACCC looked pretty closely about what was going on in other jurisdictions, and their recommendations are formulated with some of that in mind. Where I think that we are going to get caught up potentially in some problems, particularly from a trade perspective, is if we take too much of a consumer view of this. I mean, Megan's already mentioned today of the the fundamental premise of GDPR being human rights. So if we're going to take ACCC, remember there's a consumer in their title, perspective to privacy law in Australia, we're going to miss the point of GDPR. And that's not a criticism of the ACCC because that's their mandate. But I do think that you don't have the same people speaking to each other when you come to reforming the legislation. Now, what does that mean for a business? What's interesting, Damian, because, you know, I like to follow the money as an ex-financial services lawyer. And if you follow the money, have a look at the DFAT website at the top 10 trading partners for Australia. The only EU country in there, and they come in at number 8, is the UK. And we all know that as the 1st of January, they're not in the EU. So we've got a great little interactive map, and there's this big grey blob that is mainland Europe, if I can say that way. No one is on our top 10 trading list. So you and I, Damian, have spoken over the last year. Why don't Australian businesses lobby harder to, you know, get something that looks like GDPR? That's what Singapore's doing. That's what Thailand's doing. The Philippines, even Malaysia. You know, Vietnam and Indonesia are also adjusting their privacy laws for different reasons and with a different focus. But as Lee said, they all want adequacy somehow. And so even though the EU Commission hasn't actually got adequacy decisions out there, they have lifted the bar, even the DIFC in Dubai, of people desperately wanting to be in that club now and amending existing privacy laws or creating new ones to benchmark themselves against GDPR. So I think that from Australia's perspective, it's a question of how do you balance it and do you want to get left behind? But actually, is the EU really where our focus is going to be? Because China, Japan, United States, that's where a lot of our trade is. But a lot of that, as you know, is probably more our traditional trading partners, right? So if the future is about data and the future is about our reg tech industry, our fintech industry, then we've got to have a really close look at what people are doing under GDPR if we want to use the data of EU individuals. I'm happy, Damian, also to take up the point. I will actually. As the UK comes out, what does Brexit mean for all of this? And I'm sure Lee can speak to this in much more detail, but I think the problem then that Australian organisations are going to have potentially is that depending on where EU comes out with their adequacy decision about the UK, if it's an onward transfer from the UK to Australia, that's still potentially going to cause us problems. So as I said, follow the money. We may not be trading directly with those EU countries, but if we're getting EU resident data coming in through the UK, is that actually going to cause us problems anyway? Or frankly speaking, do people just not care? I've often wondered, do they just not think about these things? So from a compliance perspective, Damian, I can also talk to the buckets and things and risk-based analysis, how to think about it. You tell me where you want to take the conversation. But I do think that issue of what would be driving people to a compliance stance and wanting to move more towards GDPR is a bit of an open question for me in Australia. And therefore the impact of what does Schrems II mean is a little bit of an open question. I think it's incredibly important. And at a multinational company, it's now part of my daily grind to develop our compliance strategy, but that's not being driven by our presence here in Australia.
Okay. I mean, I suppose I'd like to get your thoughts on one other question, because I suppose we've mentioned, or I mentioned at the very outset, that the court didn't invalidate standard contractual clauses, but I mean, it kind of rendered them extremely questionable going forward. I'm wondering if you could, speak to that. I kind of leave it open because I'm happy for you to go in any direction that you want, but I've been kind of scratching my head wondering, what is the future here? And also, I suppose, about, kind of, dare I say it, kind of binding corporate rules. So, yeah, some of your thoughts on those would be great.
Let me make two comments about binding corporate rules. The first is that the EDPB has come out and said we're going to treat them the same as standard contractual clauses anyway. And really, Schrems II was not that big a surprise about SCCs. It was a bit of a reminder that you can't just sign up to your contractual obligations and then do nothing. You actually should be following through. You should have a vendor process. You should be actually looking at who you're partnering with. That's like 101 outsourcing. It's not privacy. But I do think that binding contractual clauses, the incentive to get those, I think has diminished greatly when they say it's no substitute to have binding. So you go all the way through all of the DPAs you have to get sign off on for BCRs. And at the end of the day, you still have to do everything you would have to do for SCCs. So I'm starting to think, what's the point? And I have looked at them. I've looked at the companies who have got them. I've looked at how much it costs to put them in place. It is a massive amount of money. And then I sit back and think I could get a lot of legal fees and a lot done by putting standard contractual clauses in place with my vendors or my clients than try and do binding contractual rules. I understand why companies do them, and if you have a look at which companies have done them, they tend to be more in the retail space. But the arguments for doing them now, I think, are starting to diminish. Standard contractual clauses themselves, the problem with wanting to really get up and go and start really working on getting compliant from a Schrems II perspective is that most companies who take their privacy seriously already have a program in place for making sure that you've got data processing agreements with your vendors and data protection agreements with your clients, depending on whether you're a controller or processor in GDPR parlance. So now we've got a situation where you have to do a little bit more. We're not quite sure what that little bit more looks like. We can make some guesses. But then the EDPB has also told us that they're going to come out with modernised standard contractual clauses, possibly by the end of the year that might happen. So do you start repapering deals now? Do you wait for the new ones, but then they might be unpalatable and you can get no one to sign up to them? What is your narrative in the meantime? So I think that for most companies, as I said at the start, a bit of wait and see, but a bit of, gee whiz, we'd started all those things back in 2016, 17 and 18 when we knew GDPR was coming. We'd better really ramp that up. We better use the tools we've already got to figure out who we still don't have SCCs with, or who we might need to take a closer look at because of the particular way that the transfers are working, like the volume, or whether it's information that a law enforcement agency in the US might be interested in. I think the other thing you'll start to see a lot more of, even for non-publicly listed companies, is these transparency statements. So rather than have to over and over again repeat yourself to the vendors with the same answers, stick something on the website and, you know, have a look. And if you have a look at places like AWS, they already have these transparency reports where they say, yep, we get this many requests from US law enforcement, this is how we deal with them, et cetera, et cetera. So there are some models out there of how people are already starting to try and comply. But I think at the moment, what's difficult for business, as you know, business doesn't like, is uncertainty and just not quite knowing at the moment which way to punt, because we don't want to have to go back and undo things, because to some extent we are having to undo or revisit what we thought was already set after GDPR in 2018.
Yeah, it's interesting because it just points to the sheer massive compliance burden that is linked to the application of the GDPR and its continuing burden. In some ways it work, so.
Yeah, I'm not going to get out of a job anytime soon, despite COVID-19. That seems to be the main message. But I don't think companies want to be seen to be whingers about this. I think they genuinely would like to do the right thing. And I have heard people say, well, you make lots of money off the back of data. And I think that sort of perception is a bit skewed because people are thinking of the Facebooks and the I can't remember if someone called it before, that's a data broker type organisation. But for a lot of B2B companies, data is just something they need and have to do business on a day-to-day basis. You know, you need your marketing, you need your Salesforce, your Marketos, you need your Workdays and your Cloudbase, all these big vendors that help you move around globally. It's really hard then to go, I've got to make sure that I've got buckets. But I do think that regionalisation of data and what Lee was talking about at the start today, you know, it started in Sweden, is going to be something we will see more of. And I also think that we're going to need to make sure that we have much, much better data mapping within our organisations. And people were doing that already and starting that, but this is going to really force them to move the dial on it.
I suppose, you know, I'm very interested in, you know, this increasing, you know, public-private overlap as well. And like, you know, the fact that like this seems to be pushing an awful lot of responsibility onto companies where, you know, we're sitting around now waiting for the UPB to give us guidance. But it's a very difficult position to be in. And I think, like, you know, it's probably a good time now to kind of kick off our roundtable discussion. And I kind of want to leave it open to all of you to kind of respond to each other if you have responses. So I don't have a particular order. If anyone wants to unmute, I see that you've all done it so far. So I think Megan, you were first. So if you've got something to add, please go ahead.
Okay, so I wanted to ask the question, do you think it would help if the Privacy Commissioner took a more explicit statement about, or position about which countries are good to deal with, like took a position that's rather like what the European Commission does in the European Union on adequacy? Stacey, do you think
is that for me?
Yes, yeah.
So
I know that Lee says it's very convoluted and a long process, but would it help to have at least some kind of short list?
I think it's helpful, but fraught geopolitically. And that's why I take Damian's point that companies are being asked to do things now that the EU Commission hasn't been able to achieve for a number of years. And I think that the Schrems decision can be read widely enough to say we're not just talking about the US, actually every jurisdiction you now deal with. So how many countries in the world? You're supposed to form a view on their rule of law. So I've seen things like, already in the market, people trying to use the World Bank rule of law rankings to decide whether or not a country is somewhere that you should send your data, like as one data point. And I know many of my colleagues at the Asian Law Centre of Melbourne Law School who have great disdain for some of those ranking type projects. So I think that there's going to be a lack of sophistication about how some people will approach this. And therefore, Megan, I think some leadership from the regulators, whoever they may be, would be welcome. I would be interested in Lee's view, because I'm not necessarily sure it's going to come anytime soon.
Well, if that's over to me, I agree. I don't think it's going to come soon. And I don't think frankly, the data protection authorities, the privacy commissioners at federal or state level in Australia have had the resources to do this sort of stuff. You know, they've got other fires to fight, and yeah, replicating to some extent other organisations' work isn't going to be a good use of resources. So I just can't see it happening. In an ideal world, yeah, it could work, but even the European Commission is very, very careful about blacklisting countries, and the white list it has is a very small list relative to the large number of countries in the world, as Stacey was intimating. Yeah, but I want to just take up another point. I was intrigued by what Stacey said around you know, where money flows, and you said, I think quite rightly, look, you know, follow the money. And this is what the European Commission does as well, to some extent. And that's why there was so much effort put into getting a safe harbour agreement between the US and the EU, because of the sheer number of, you know, the implications for trade flows, which were at that time, back in the late 90s, you know, meant to be far greater than any of the, you know, controversy going around the banana trade or whatever. It was huge amounts of money. And again, that's why New Zealand, I together with Graham Greenleaf have argued a while back, that's why New Zealand was able to get an adequacy decision despite not offering perhaps a perfect vision of or version of EU adequacy, simply because it was far away and the amount of data flow and the trade implications from that data flow were pretty minuscule. And again, I think that's why the negotiations between Australia and the EU for so long have been put on the back burner, because, hey, Australia and the EU and the various member states of the EU are not, the data flows and the trade implications of those data flows aren't really, really big. So yeah, money does play an important role here. But that doesn't mean that in principle and further down the track, we can just keep those negotiations and reform efforts on the back burner. They're going to come back and they're going to bite us at some stage.
Yeah, Megan pointed that out too, with, you know, the argument of sometimes it's just the right thing to do, and then how are you going to allocate your right resources behind it?
But I think that the security question is also another huge complication, isn't it? So it's not just about following the money. It's also about looking at real political priorities. And I think security does seem to be one in Australia. Is that going to be really a major problem in the future for any kind of, anything beyond individual companies working out their own arrangements?
Well, I can jump in there and tell you that I don't see the trend towards empowering law enforcement and national security agencies to do whatever they feel like they need to do to be able to keep Australia safe, being arrested anytime soon. I mean, I often joke when I talk about this sort of law with my students that what the government tends to do when introducing this sort of stuff is say we're going after pedophiles and terrorists, and that's a pretty, you know, it's a pretty good opening shot in terms of why you're trying to expand the powers of the state. I mean, and just in terms of, you know, information flows, Australia is very committed to its position in the Five Eyes relationship in terms of intelligence, and the links between the Five Eyes and the European Union are going to get more attenuated once Brexit happens and the UK leave. So that might be interesting, but as long as Australia feels secure in its position in the Five Eyes, I don't know that there is going to be anything to counterbalance the logic of trying to ensure that Australia's legal framework is about protecting Australia's domestic security as best it possibly can.
Maybe throw something in there. Sorry, Stacey, go ahead.
No, you go. No, you go.
Well, I mean, there has been a lot of discussion about, trade here and the lack thereof potentially between EU and Australia. And I suppose, Dom, if you're looking for some kind of a catalyst maybe for change, it might be that there are trade negotiations ongoing, at least to the best of my knowledge, between the EU and Australia. And interestingly, I had to look at what the starting position of the European Union is, and that the starting position for the negotiations between the jurisdictions, and it effectively says that both jurisdictions recognise the right to data protection and privacy, which of itself is incorrect, and that they both then they define personal data in line with the GDPR. So I'm kind of wondering, like, is this an impending mess? Is this going to be something that is kind of an afterthought in terms of the effects of the Schrems II decision and all of this, the historical, inadequacy, I suppose, as judged by the European Commission of the protections that are afforded in this jurisdiction? And I suppose, Dom, to you, in a way, I'm wondering whether economic reasons might be a push to change, because I suppose follow the money again, to a certain extent, you might get some leverage for change of domestic surveillance powers if it's going to hurt the pocket a bit more.
Yeah, look, you'd think so, except the reason I'm hesitating is just reflecting on the way in which the Data Retention Act progressed through the Parliament. So, that was the change to the Inception Access Act, which said that telecommunications companies had to retain data for 2 years so that there was enough of a digital footprint for law enforcement to collect, in the event when they were investigating these things. And cost was a really big factor that the private sector put up. There was a very interesting parliamentary committee process where, one of the points justifiably made by the telcos was, well, it's going to cost us a lot of money to get the sort of server space to store this stuff for this amount of time. And the government's response at that point was, okay, we'll set up a system where we will give you government financial assistance to be able to achieve this this security goal. So, look, I don't know. I find that security is really a trump card in these sorts of arguments. That there's when they're trying to secure the state, that even economic considerations tend to take a backward step. So, we can argue about whether that's the right public policy response, but that seems to be, at least in this particular corner of the world, something that is coming up. And even with the Assistance and Access Act, the idea that these companies might be betraying commercial in confidence information was a theme in some of the discussion that was had by the independent monitor. But it wasn't enough to say, well, we just shouldn't give the state these intrusive powers or these abilities to co-opt the private sector to achieve national security goals. So it should be a counterbalancing weight, but it doesn't tend to always work that way in my observation, at least over the last 5 years.
Does anyone else want to come in there, or will I go with another question? Or does anyone else have another question?
I think the security issues are being brought more and more to the fore in the context of our relationship with China. And so, once again, if you have a look at the DFAT stats, guess who might be further up the list than the EU in who we might be caring about, but we're caring about it for a very different reason. So one of the things that I also have been following with my patch is the Chinese cybersecurity law and the data localization requirements there, which are framed very differently and perhaps have slightly different goals to the EU, but are coming out in similar places. And so one of the things that interests me is that we'll end up with these regional blobs, and some of it will be around trade and some of it will be around security. And so from Australia's perspective, if you look at who we're trading with and who our natural security alliance is with us, once again, I don't see the impetus for going down a GDPR path per se, other than it might be something we want to do from a human rights perspective. It's not the narrative I'm seeing at the moment.
Yeah, I mean, that's interesting then, and maybe Lee, I'll ask you a question then kind of on this basis. I mean, do you view the Schrems decision and I suppose the policy approach? I mean, it's a court decision, so it's not really a policy approach. I mean, you could say that the commission approach is very different from the courts. I mean, as far as I know, there's very strong rumors that the European Commission is actually looking for take 3. But I'm kind of wondering, you know, is the effects of the judgment and looking at its larger kind of policy implications and implications for business kind of isolationist in a way, because it's kind of pointing to what Stacey just said. Okay, you might have reasons for localized storage from a security perspective if you're a certain state, and then you might have other justifications from, I don't know, a fundamental rights perspective on the other side. And Megan, I'm happy for you to come in on this one as well. But Lee,
I'm wondering if it's isolationist or if it's just that Australia is looking to the US and not just to Europe, and thinking about its relationship, like the Five Eyes is a good example there. So wanting to maintain that security alliance very strongly as part of our security plan. And so I don't know, it was always very strange, seemed very strange to me that Australia had so much trouble getting any adequacy, whereas the US did, but now we seem to be on the same side of things. So is that going to continue in the future? I don't know. What do you think, Lee? Do you think the US will work out some deal and that might open the door more for Australia in some stage?
I don't know. I can't see the political landscape in the USA changing significantly quickly and significantly substantively, despite whatever election result we get in November, to meet the standards that the Court of Justice of the European Union has set out in both Schrems I and Schrems II, with respect to the ability of US law enforcement agencies to suck up and analyse personal data flowing from Europe to the US and indeed, you know, many other pipelines around the world. So that's not going to happen overnight. You know, there's I think a fairly fundamental difference between the way in which the US governance system is built up and the way in which the European Union system is built up. But we're talking about the European Union one is a much more dirigist, principles-based approach, which is reflected in its data protection legislation, but also in other areas as well. The US is a much more sort of bottom-up, we do things as we go on a need-to-do basis, you know, across many regulatory frameworks, and that's not going to change overnight. So there'll be, I think, this sort of impasse that maybe the SCCs can paper over to some extent, but the Court of Justice is also indicating that standard contractual clauses aren't necessarily going to be the silver bullet here. If they don't deliver as well, then, you know, they go out the window. At the same time, the Court of Justice has given a lifeline to standard security use of contractual clauses by saying, you know, they can be adjusted, they can be supplemented, they are not wrought in stone. So if controllers have the resources and you know, follow what they're meant to do under the law, they may in fact deliver a safeguard that is in compliance with the adequacy requirements of the EU law. But yeah, at the same time, people like Chris Kuhn have said, well, the wheels of enforcement turn slowly also within the EU, so it's going to be maybe quite a while, maybe even a year or two longer before regulators in the EU start to sort of wave the big stick and say, right, these contractual clauses with this particular country or this particular company, they don't pass muster. So things aren't going to happen overnight where there'll be this sort of impasse that we're all looking at and going, oh, you know, but the writing is in a sense on the wall. When it comes to Australia, my sense too is that, again, we have two very different ways in which we approach regulation. So the Australian way is a bit more like the American way, minus a Bill of Rights, which is even more problematic. Australia, I think, is a Benthamite outpost par excellence. I find it hard to identify another Western legal system that has such a sort of utilitarian, sort of right skeptical philosophy as the Australian one does. So even our counterparts just across the Tasman Sea managed to sort of adopt some rights type thinking that is rather somewhat equivalent to what happens in the EU. But yeah.
Well, sorry, can I respond to that and say,
sure.
Yes, we're very, well, actually I'm a New Zealander as well as an Australian, so it's hard to talk for both separately. New Zealand has a Bill of Rights Act, but it doesn't have a right to privacy in the Bill of Rights Act. It has other things. US has a Bill of Rights that has a First Amendment, which is almost dominant when issues come up about the First Amendment or the Fourth Amendment, but it doesn't really have much by way of a privacy right. I don't know that you necessarily can assume that when you have a Bill of Rights, privacy gets treated in a way that you'd want to see it treated. I'd like the European approach, which has privacy and free speech and other rights in there, the Charter and the Convention. I think Australia is very strange because we do not talk about rights a lot. We talk about interests rather than rights, but we actually seem to take privacy seriously more and more. And I think if you look at some of the recent cases, like the Smethurst case, you'll see there's quite a lot of interesting language in there about privacy as something which should be taken seriously. And also in the New South Wales case, but also in other common law cases. And I know that they take a while to come through the system, but they do seem to reflect some kinds of ideas about privacy as a fundamental value, if that's what you think a right is, essentially. It's just the difficulty, I think, with it not being a constitutional right, is that then you could have legislation that really just tramples all over it. And what can you do if you don't have a constitutional right, if it's really clear what the legislation's on about? So I think in the end, or executive actions, I just think in the end, that's really where the crunch point comes, when they're very security focused or politically focused decisions taken about what should be done, that there's no comeback against that in the name of privacy necessarily. I don't think we've reached that point in Australia, but I do think that it would be nice to have the extra protection of some kind of constitutional privacy standards that are more explicit than what we have now.
Well, thanks very much. I see that there was a question, I think a comment more from Norman Wheatsip in the chat. Stacey, I saw that you were going to answer that one. I'm not sure if you want to take it or
my apologies. I managed to delete Norman's comment as I was trying to respond to it, because it seems that I went back to say I'd respond to it live. So I think Norman was saying, Damian, first of all, that you had done a great seminar and putting it together, but also pointing out that the EU is a very large trading partner for Australia. I think you need to take the UK out of the stats and then see how much is left. But have a look at the DSAT interactive map that I've just circulated, because a picture tells 1,000 words. I don't think that that diminishes the importance of the EU to Australia. I just think it helps to put things into perspective when you think about why aren't we trying harder in some ways to move towards GDPR? And, trade's got to be a big part of that. Security's got to be a big part of that. And I just wanted to also pick up separately on Lee's comments about how long this has got to play out, and why when you're developing a compliance strategy, you may not want to be the first mover. You want to have your house in order. You want to have a compelling narrative, and you want to show that you're trying to do the right thing. But at the end of the day, Facebook is still appealing. They've thrown their hands up and said, you're going to ruin our business model. We can't actually service anyone with Instagram anymore in Europe. So there's a long way for this still to play out. And then you've also, as Lee said, got the possibility of a third run at a privacy shield type issue. The Swiss have now come out and said, we've got concerns with the US Swiss shield, but who knows where that's going to end up. Because initially we got some really interesting immediate responses from clients and vendors, people saying, we want to delete any reference to the privacy shield in our contracts. oh, but what if they do get another one up and running? You know, do you want to do that? And the FTC came out then and said, whilst the EU said it's invalid, we're still going to, you know, enforce it. And, you know, if you said you're going to do it, then you should do it. So there was a lot of really immediate reactions, I think. And sometimes with these things, you need to stay the course. And hopefully you've already got a compliance strategy that you can say to people, well, actually, we're doing these things. And yes, we're now taking that into account as well. And we'll move forward on that basis. None of us really want to be the one that is doing nothing. But by the same token, you want to also make sure you set yourself up to be able to comply with whatever does come down the pike and not have to backtrack either. So it's an interesting space to really try and judge that on a risk balance perspective to help protect, well, my client, essentially.
I might just jump in too and just say, you know, we've also got a raft of, we've got a judgment in a number of joint cases that will probably be handed down by the Court of Justice later this year, which also deal with law enforcement agencies' use of personal data. Damian, you probably can elaborate if need be.
No, I think we're kind of running out of time now at this point. So, I mean, I'd like to kind of, rather than rushing the thank yous, I'd like to kind of maybe just take the last 2 minutes to say thank you very much to all of our speakers. I think it's really been a great conversation. It was exactly what I had in mind when I thought of having this event. So I'd like to thank all of you. I think it's really helped my thinking around these issues. And I'd like to thank everyone else, everyone for attending as well, and also to my colleagues in the marketing team, so Tom and Jihan, for helping me put this together. But I think that's it. So thanks very much, everyone, and hopefully we can continue the conversation in some form. So thank you very much.
Thank you.
Thank you.